Who do we have at the county jail, please?
Chelsea Brink.
All right, Ms. Brink, let me find your case on my computer and we'll call them. There are two of them. All right, this is State of Michigan versus Chelsea Brink, file 25-44051-FY, set for a probation violation. And then we also have file 25-44174-FY, set for a status review. Mr. Brown, are these your cases?
Yes.
All right. It looks like the probation violation is based on the new charges that are contained in the second file that I mentioned. Where are we at on that new felony criminal file, which I believe has a prelim set for next week?
Your Honor, at this point, I called the jail the other day to speak to some people. I did inquire about Ms. Brink. I did not speak with her. I was advised that may not be the best time to speak with her. At this time, I believe, given the history here and what I know of some other cases going on, I am going to request a competency evaluation at this point.
No, you're not. No, you're not. Because I've already done that and proven myself to be sane one time, and you don't have to do it more than once.
Okay, Mrs. Brink, the issue before the court is not insanity. The issue is competency, which is an ongoing.
And that's what I did.
So
I did.
Okay, I understand that you did that in the past, but the question is whether you're currently today competent, not whether you were in the past.
Yes, the law says once you've proven, you don't have to do it once. I researched it while I was in prison.
Well, I'm sorry that you took the time to do that, but that's not accurate. The question is ongoing one.
So you pull up the law on that?
I'm sorry, I wasn't able to hear what you said, Ms. Brink.
I said I request that you pull up the law on that right now.
I've reviewed it a number of times. It comes up in my business on a regular basis. Okay. Your attorney is entitled to ask for that.
Well, I want a new attorney because that's not fair to me. I've already done this once. I am competent. I was freezing to death. I was homeless. I am homeless. And I went to the only open establishment to warn.
Ms. Brink,
no.
You're getting into facts of the case that you probably don't want to do.
Those were facts. Those are facts. I went into the only establishment that was open.
Your Honor, I would request the jail be muted.
Which the law states that if you're in.
Ms. Hill, mute the jail, please.
Done.
Ms. Brink, you can't talk out of turn, number one. Number two, it's not in your best interest to be making factual statements over the advice of counsel. That's why I muted you at this point. Your attorney is entitled to ask for a competency examination. So I'm going to ask him to put that in writing. Once he puts it in writing, I will grant that request for an order, and then we will decide where you go and what you do from there.
I will not participate. I will stand mute.
You can certainly do that if you wish, Ms. Brink. That's your right to do that, but it's also your attorney's right to ask for a competency examination.
Illegal.
I'm sorry, what did you say?
I said it's a waste of the court's time, which is illegal. You cannot waste the court's time.
I don't think it's a waste of time to make sure that your rights are being preserved.
I'm telling you, I will stand mute.
You're free to do that if you wish. All right, we will adjourn the probation violation.
That alone proves that.
PV hearing will be adjourned pending the competency exam. And Mr. Brown, if you would file your request for competency examination and attach a proposed order, I'd appreciate that.
I will do that, Judge. Thank you.
Thank you. That's all for Ms. Brink today. Thank you very much, Ms. Brink. You're free to go.
Ms. Brink, please don't do that.
Fuck you. I don't want you as my attorney.
Have a nice day, Ms. Brink.
Yep. Okay. Go.
Will you hand me my screen box?
Now go. Preach. Rah.
Mr. Bassan?
Good morning, Judge. I'm here on the Grandison sentencing. I'm on a quick break with my hearing now, Your Honor.
Okay, well, good morning, but this is in person, counsel. Do you have permission to appear via Zoom?
I was told each sentencing was done by Zoom, Judge. Because we zoomed in
No.
all the prior hearings.
No, on Thursdays, the only thing that's on Zoom are PCCs.
Oh, really? That's new to me, Judge. And I truly apologize. I'm
Not sure why that's new, because that's how it's been. The only sentencings that are permitted on Zoom are on Tuesdays.
So I apologize. I didn't know there was a distinction between the Tuesday and Thursday sentencings.
Okay, so how long until you're here, counsel?
Well, Judge, here's the problem. I'm literally right now as we speak. And this is no lie, Judge. I'm literally in another trial right now. So we were on a break now, with the jury, Judge. But I don't know if I can leave today and come down in person. And honestly, I didn't know there was a
Where's the
distinction
Grandison
between
file,
Tuesday and Thursday.
please? Hold on, counsel, please, hold on. Do you have the Grandison file right there? I believe we already adjourned it because you were in trial previously, correct, counsel?
I will. That was in a murder trial 2 weeks ago, the last time, Judge, and I'm in a jury trial today. So I do apologize.
Counsel, do any of your notices indicate that you're appearing via Zoom?
Judge, my previous ones have, Judge, and I was on the record on Zoom, Judge. That's why I said it was never, even when I spoke to probation, I got an email one time saying that the sentencing was by Zoom. So I'm really not making that up, Judge. I'm really not.
Your email indicated that it was via Zoom. That's what you're telling me, counsel?
I said the email that I received from the probation department.
Told you that this sentencing was on Zoom.
That was my
Talking to
belief,
everybody
Judge.
else. You called me and talked to me, but when she did,
I'm sorry, somebody was speaking over you. What was that, counsel?
No, I said that was always my communications, Judge, and I'm not making that up, Judge. I'm really not.
I'm not understanding what your communication was.
That the sentencing were being held by Zoom, Your Honor. And this was directly at the time that my client.
Hold on. You have an emergency motion to vacate conviction, so it's a motion hearing also. I do not do motion hearings via Zoom.
Judge, if you look in the file, Judge, that motion was denied. You denied that motion, Judge. And the only hearing I missed was the last one because I was in trial, and now I'm in trial again today. But that motion hearing you denied.
No, counsel, I denied the December 4th date, and I denied the emergency basis. I didn't deny the motion. We haven't done a motion hearing on it.
Judge, I submitted my motion. I got an email from the court saying the judge denied your motion to vacate count 2. And
okay,
counsel,
counsel, I'm going to step off to double check and see what communication you've received, because I'm reading my notes right here. Emergency status not granted, set for hearing November 13th. Okay. Then November 13th, you sent in an emergency stipulation to adjourn pretrial, and you wanted it to be set for December 4th. The court denied that date and set it for a different date. The court has never denied your motion, counsel.
Judge, Judge, listen. I can email the court and show you exactly what the court emailed me.
Counsel, did you just tell me to listen? Is that what you just said to me?
I did not say
I just said I'm going to step off to see what communication you've received. But I do not appreciate being told to listen. So I'll be with you in just one moment.
Everyone please rise.
We're not together.
You may be seated.
Yeah. We'll stop. Mr. Morsky, I need you to hit the join on the breakout room. Okay, it looks like she's joining now. Okay, let's go. Let's go on the record in the matter of Darius Grandison, 251089. The state of Michigan versus Darius Grandison. Counsel, your appearance for the record again, please.
And good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Mr. Darius Grandison, who's present in court. Mr. Grandison, please state your name for the record.
Darius Grandison.
Okay, so counsel, let me just go through this procedure here. You were here for probable cause conference and you were in person on an exam on September 4th, for an exam on September 4th. It was not held, your client pled to a misdemeanor. Then this matter was scheduled for October 14th for sentencing, which I believe you were in person for. And the sentencing was not held. You adjourned it to resolve count 2, and then you were going to be submitting a motion to withdraw the plea on count 2. And the sentencing was adjourned to November 6th. November 3rd, the court received an emergency motion to vacate conviction. The court reviewed that, and the court made a note on November 3rd, emergency status not granted, set for hearing November 13th, removed sentencing from docket and adjourned to November 13th. Okay? You received an email on November 3rd. Judges reviewed and denied the emergency motion. The motion and sentencing have now been set for November 13th. So there was a miscommunication with some of the language that was sent to you. However, it also indicated that the motion and sentencing had been set for November 13th. So I denied the emergency status of your motion, but did not deny your motion, counsel. Then you had sent in a stipulated order to adjourn the pretrial. And then ultimately that was granted, but a different date. Then you were still stuck in the homicide trial, so we set it for today's date. And now here you are on Zoom for a motion hearing and a sentencing, which we are not doing via Zoom.
I understand, Your Honor, and no disrespect to you or your court judge, but Your Honor, I just got called back into this court with this trial judge. This trial was set for December 2nd. It was supposed to be over with by December 4th. Then it got moved to today. And Judge, I've had no time to let the court know in your case, but I'm not trying to disrespect you or your court, Your Honor. But Judge, I literally just got called back into my court for this trial, Your Honor.
Counsel, can you be here next Thursday, December 11th?
I will be there, Judge, with
person for your motion hearing and your sentencing.
Thank you, Judge.
December 11th, what time, Allie? At 10 a.m. And counsel, just for future reference, please do not say, listen, Judge, okay? Did he just sign off? Are we for real? Did he just sign off?
Good sentence.
Mr. Granderson, we'll see you back on December 11th. It's not your fault, sir. 10 a.m. Okay, does that work for you?
Yes.
Okay, and I do apologize that you're continuing to be here. And I'll say that sometimes some court things are outside of the control of the attorneys. Sometimes you can't guarantee, or the length of a trial is sometimes out of the hands of the attorneys. So, but had you had any communication with your attorney?
Not about that, no.
Okay. All right. We'll see you back next week. Have a good day.
You too.
You can put him on our list that has to appear in person, not on Zoom or anything. We'll be here at the time of 10 a.m. Can you please send an email to Mr. Bassant letting him know that the court was still speaking to him when he abruptly hung up?
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
No patience there. Trust me, after today, I'm sitting up here, I'm the one that needs a drink.